Welcome to another of NJAPM's webinars. Today, we have a very interesting webinar, and the topic is what you should know about the free application for federal student aid, FASFA. So we have Sandy Voigt, who is an expert in this matter and will be talking to us shortly. First, I want to thank Diana Longo. Diana came up with both Sandy and the idea for the day's presentation. And it's really helpful to me when you in the association come up with ideas for future programs. Frankly, the idea is the hardest part of this whole process. So thank you, Diana. So Sandy, why don't you introduce yourself?
Sure. I'm Sandy Voigt. This is my third career as a certified divorce financial analyst, but I spent 27 years working in higher education, among other things being a director of financial aid. So I have sort of carved out a little niche in the divorce world of helping families who have children getting ready to go to college and trying to find ways to optimize their basically a financial aid for their students. And today, the challenge will be the FAFSA, the free application for federal student aid, has been in effect for many years. I took my first training in 1983, and there's been very few changes until this past January. And I'm going to start reviewing with you what those changes are, how they're going to impact your clients, and maybe even you if you've got children who are going to be hitting the college circuit pretty soon. So with that, I guess I'll just put on my share screen here. And
yes, while you're doing that, Sandy, let me mention that Sandy will be taking questions throughout the presentation. So please enter them in the Q&A function, and I will be fielding the questions for Sandy.
So for a couple of caveats first. One is that you're going to hear me clearing my throat a lot. It is major pollen season out here in Seattle. So there's that. The second is, as the sun rises above a certain point, the glare from the skylight will probably bounce off my head. I apologize if I remind you. And the third is that we have a big German Shepherd, and we live on a very small, quiet street. And anytime a car passes, or probably an Amazon truck comes down the street, she'll bark. So if you hear that, it's just, that's what's going to happen. All right. So these are some of the changes that have happened most recently. Just now 2 months ago, in the stimulus package. Remember, college students who are now dependents now qualify for the stimulus checks, but the checks go to the parents, not the students. And student loans that are forgiven, at least through the 2025 tax year, are not going to be treated as taxable income. And after 2025, that's a sunsetted provision. It will go back to the way it used to be, which means if you got a loan forgiven, it's treated as taxable income. When President Biden took office, the next day, among many of his executive orders was one that is waiving any payments through the end of September of 2021. And so if you have any child or client who's on an income-based repayment or a public forgiveness loan, they should not make any payments. You know, people are saying, well, there's no interest, I'll make payments, I'll bring the balance down. The problem is that means that there's less that money you're paying in. Ordinarily, if it's a balance you still had when the time of the 10 years for public forgiveness, or 15 or 20 or 25 years for the income-based repayment ones, it means you're not going to get that money back. So I tell people, don't make the payments now. And any payments that have been waived, which started in March of 2020 and now through September of 2021, are going to be counted or credited towards those monthly payments, consecutive monthly payments made, which is required for 120 consecutive payments for public service forgiveness. Those are all going to count. So these are all good things. And what else? Okay, I've got a short period of time, so I'm just going to, you can get access to this stuff later. I'm assuming that Carl, I can send a copy of this slide deck to you when we're all done. You can.
Yes, I will distribute it to everybody who has attended.
Okay, great. So here are the changes that were made. In January of 2021, still under the Trump administration, there was a COVID relief bill, roughly 5,000 pages. There was a 167-page insertion called the FAFSA Simplification Act. Maybe a little overreach for terms, but some of them make sense. Others are going to be great advantage to people. Others are going to be a disadvantage. And I'm going to I'll take you through those. But remember that these don't take effect until the academic year that starts July 1 of 2023. So if you have a student who is starting summer school before that date, so they start summer school in June, this still doesn't apply yet to them. But if they start summer school after July 1, it does. So for the 2023-2024 academic year, that's what's key. And that means that they fill out the FAFSA in October of 2022, and they're going to be using their 2021 income taxes. So what that means is that anyone who is a high school sophomore currently is going to be impacted only by the new rules. The old ones will not apply. But that means that high school juniors, to people who are already in the first year of college, they're going to have to switch over. And of course, anyone who is a sophomore in college and above, it's not going to impact them because they will have completed their FAFSA's requirements by that point in time. So the first simplification thing is there used to be 108 questions. Mark Kantrowitz, who is probably the person who you see most likely quoted in anything about financial aid, wrote a free downloadable 250-page book on how to fill out a 6-page form. Not that it's complicated, but it's certainly challenging. I'm assuming he's in the midst of writing a new one, but they did ask a question for the first time about race. So because they always ask questions, about racial equity, and for the first time, hopefully the Department of Education will be able to answer that question. So those are the changes that are the structure of them. So the first thing is that for those of you who probably had your own experience of financial aid, or maybe you've already had your students in college, you filled out the FAFSA, and the key was you're going to get this student aid report, which would have the expected family contribution, the EFC. The first thing is they're going to change that name. It's a misnomer. Expected family contribution, I think, made people assume that that's the only money that had to put in, and the truth is that's not the case. So they've now called it a student aid index. And for the first time, they're also giving people credit. So you can actually have a negative student aid index, which means that people really at the lower economic spectrum are going to be able to get additionally as much as $1,500 more than the cost of attendance. Of course, there's always going to be expenses that are not included in that would otherwise not be covered. And this is, if people at the lower end are borrowing money, it's just harder for them usually to repay it. Excuse me.
Sandy, we have a question, which is, should parents declare their college-age children emancipated to take care of the aid available?
Good luck on that one. I've had to sue, when I was a financial aid director, we sued parents for emancipation. Ordinarily, parents don't want to give up the various benefits, but the default from the Department of Education is you are automatically considered a dependent student if you're under the age of 24. If you are single, you are automatically considered a dependent student. You're an independent student if you're a graduate student. If you are if you're married, if you're an orphan, if you're in the armed services, then they will consider you independent. But other than that, it's going to be a hard. You'd have to really show the Department of Education that you have provided no support to that child in that time. And that's going to be for most people, a really hard thing to do, and it's a time-consuming process. So just because you want to make emancipated to get more aid, it doesn't mean it's going to happen.
What happens if you've got a court order declaring emancipation?
That would be, I believe, a document that you provide to the Department of Education to prove it. And it depends on what school you go to. Sometimes the Department of Education will just have you provided to the financial aid office at the school in which you're going to be attending. But they're going to challenge it, just to let you know that. Okay. Documents are easily forged in the state, and they may ask for a thing directly from the court, directly not given by the parent.
Okay.
Okay. So typically, when the old days, and you got an expected family contribution, um, the challenge there, not the challenge, but the structure is so that if I had a AFC of $20,000 and I had more than one child going to school, that $20,000 would get divided among however many students are going to college. So if I had two kids, I don't have to provide the first $10,000, and then the financial aid should make up the rest. That is changing. And you'll see I've color coded with smiley and frowny faces, blue for for feeling blue, because these are not good things for people, and the red for these are great things for people, I think. But in this case, this is going to be for many middle-class families with more than one child in college. This is going to be a hell of a hit. So that's the first thing. It's no longer divided. The good news is that people at the lower end of the spectrum, if you have a 0 student aid index, doesn't impact you at all because you don't have to put anything in. But that's a small lining in this harsh ruling. This is one thing I suspect, given the politics, that there'll be a lot of pushback from middle-class families to their congressional representatives. Maybe this will change, but I'm not hopeful immediately it's going to make an impact right away. So typically, under the current method of FAFSA, we've used to structure these financial aid agreements between divorcing parents saying, look, your child would likely get more financial aid to the lower income parent. And then we have to figure out excuse me, the custodial agreement, because it doesn't matter what your agreement says. The Department of Education says whichever parent has a child sleep at their house one night more than the other parent, that's the custodial parent, period. And they're the one who fills out the FAFSA. That's the only definition, and that would trump whatever is your divorce agreement. So that's the first thing. The new one, though, there's some changes. One is that if the parents are married, or even if they're unmarried and living with someone else, whichever parent completes, you have to use the entire household financials. So that's a big change also. So it also could be, sometimes you have these agreements that the person is going to be responsible for filling out the financial aid, and they are living with someone who, who has a lot of resources, and all of a sudden they're not going to be eligible for financial aid. So that's something to consider going forward as well. And the new regs are saying that whichever parent provides the most financial support to the student is going to be required to fill out the FAFSA. That's a major change. And the challenge there is, some people say, well, we're doing everything 50-50. No, it's not a problem. We're both providing the same amount of support. The tiebreaker next is, okay, whichever one has the greater adjusted gross income, they're the one who fills it out. And should that be a tiebreaker as well, the final tiebreaker is the student's driver's license, which whatever address is on the student's driver's license is the one will be the final tiebreaker. It's interesting what the Department of Education comes up with, but that's the new rules. So a number of positive changes are what's going to count as income. In the past, it was pretty inclusive as to what they counted as income for the parents, and now they're saying a lot of things are going to be excluded. But the first is that child support, even though it's tax-free, from a financial aid perspective, it's still counted as income. And that's changing. It's now going to be considered an asset. So why is that better? Well, incomes are assessed at up to 47%, but assets are assessed at 5.64%. So if you receive $3,000 a month in child support currently, your expected family contribution would have increased by almost $17,000. Under the new ruling, under the new structure, it'll only increase it by $2,000. So that's a major positive change for most of our clients. It used to be these things that now you have these red smiley faces. These are changes that have now made these things excludable. They're now no longer going to count workers' comp, any VA or military education benefits. If you are clergy, military allowances for housing, that doesn't count anymore. The big changer here is 529 plans. If they are owned by the parents or anyone outside the household of which of the parent who's completing the FAFSA. So, any grandparent 529 used to be a significant hit in the second year. It's no longer the case going forward when the new plan takes effect. As long as a 529 plan is not owned by the household. So again, one of the things you can structure in this thing is if under the new rules, you might change ownership of the 529 plan if the parent who owns them is going to be the custodial parent. So that's a usually easy thing to transfer. By the way, for the student, college work study will no longer count as income either, and nor will the American Opportunity Tax Credit or the Lifetime Learning Tax Credit. They're not counted as income. And of course, the portion of scholarships that don't apply towards tuition and fees. So if you got a full ride tuition, it covers room and board and books and supplies, that used to be considered income to the student, and that's no longer going to be the case either. So these are all, for the most part, these are all major positive changes. Whether they'll outweigh the expected family contribution, division of how many students there are in the household, that's still going to be a house by house household determination from everybody. But these are the sorts of things that you want to look for your clients as saying, these are positive changes for everyone going forward. And again, most of these are middle class and upper strategies, but still really valuable for students.
Sandy, a question is, how does the new calculation affect step-parent income inclusion?
So it's going to, again, it's the Department of Education says it's household income. So again, if a parent remarries, but they're the custodial parent, their entire household income and their assets all count in the process.
And if I wasn't quite sure, it seemed as though it was saying that if one parent is just living with another person, does that count too? Or is it?
The Department of Education says if you are renting a room in someone's house, that's not counting. If you're living in the same bedroom with another person, that counts. Now, truth is, I have no idea how they would know unless the former spouse rats them out, right? There's a lot of things that are, people have not abided by because they were ignorant of the rules, and sometimes find out because there's a financial aid audit. Remember that the Department of Education has mandatory audits randomly assigned to people that the financial aid office of the college carries out. And the financial aid office at every school can also on their own instigate an audit. And for example, I will tell you that when I was a financial aid director and a student who's getting a lot of financial aid, drives into school, gets a parking permit for a brand new car, you better believe that they're going to get an audit, right?
So that even though that person, the parent is living with, has no legal obligation with respect to child support, none at all,
None.
It's still going to be figured in.
That's right. And remember, it doesn't matter what the divorce agreement says, it's the Department of Education rules that carry the day. So, you can say it's only going to be, the parent, divorced parent, who's going to be now the custodial parent, and they're responsible for filling that out. And the assumption is that, they're going to get better financial aid and they wind up living with someone or get married to someone. I always tell people that's a potential major hit on financial aid for people. Okay. So I'm not sure I'm going to spend a lot of time on this slide per se, because you'll have this thing here, but they've made some changes into the who automatically qualifies for a zero student aid index. And these are for both dependent students and for independent students. So these are the criteria you have to follow to see if you would automatically get a zero index number. The thing I'm going to mention the last couple of things here. So typically, if the applicant, if they're independent or if the applicant's parent, if they receive a means tested federal benefits, SSI, SNAP, that should be that's a typo, TANF, and WIC, Medicaid, or federal housing assistance. If they got that, they're going to get a 0.8 index, which is great. It used to be that if you qualify for the free or reduced school lunches, that would also qualify you, but that is not currently on the list. Not sure why that was omitted. And there's a request into the U.S. Department of Education to a petition to get that back included. Haven't heard from that. A lot of these things, the law is it's 167 pages and pretty specific on a lot of topics. So they vetted this thing out, unlike a lot of things, but there will be some either unintended consequences or a lot of pushback politically that may change some of these rules and regs, but they haven't published the rules and regs yet. So we're still waiting for those, but I got to imagine since it's 167 pages and it was written, I think, over a long period of time and just waiting. It was the last Trump legislation thing that Senator Lamar Alexander had inserted into that stimulus package that everyone was going to pass. Just one of those ideal storms, right? So the question came up in an earlier presentation that, how do you get this negative student aid index? So if you're not required to pay, to file a federal income tax return, again, that PPY is the prior year, then you're going to qualify for that minus $1,500. That's not, remember, it's not if you, it doesn't mean, the difference between not filing is different than not required to file. So for those people who just decide they didn't file and they could qualify, that doesn't count. It's that there's lots of regs as to what excuses you from having to file. This would be one of them. So positive things for the most part. Pell Grants are going to be significant increases, at least that's the plan for 2023, 2024, which they haven't yet announced. I know that for next year, the Pell Grant is about $6,500 for next year. I think the Biden administration is talking about a 20% increase for 2022, 2023. And hopefully another 20% increase after that. So that could be a significant, I think you're going to get up to about $10,000 for Pell Grants is the expectation by 2023, 2024. So that's a great thing. But they're now using the poverty levels, and which on the last slide of this presentation, you'll see the chart for what's a poverty level, and then the percentages of what level of income families can have to qualify for the maximum Pell Grants. So that's just there for you. I'm going to do some, okay.
Sandy, we're getting a lot of questions here,
Sure.
Sort of incredulous questions. One is, isn't household income the combined income of the mother and father after divorce and does not include the step parents?
No. So the way it works right now is, it's only the custodial parent fills out the FAFSA. Now, if you're a divorced family and you're going to, and if a student is going to any state college or institution, whether it's in-state or out of state, it's only the custodial parent who fills out the FAFSA, and that's it. If you go into a private college, about 650 of them require the College Scholarship Services profile to be filled out. That's filled out by the other parent. But only those students going to private colleges that are in that 600 plus. And plus, in addition to that, many private schools may ask the other parent to also provide that information. But for the parent who has to fill out the FAFSA, again, this is a federal thing, they're required to report household income and household assets. So that's the distinction, if that helps.
So household being the people who actually live in the house. So it could be a man and his girlfriend who lives there. Is that household?
If they're living together as if they are married, basically sharing a bedroom, whether they're same-sex couples or not, that's what should be filled out according to the Department of Education.
Okay,
Again,
and if the parents are,
how they find out is,
okay, and if the parents are divorced, then they are not a household.
correct.
Okay, I think that's okay.
All right. Any other questions?
That's going to be a real surprise for some people.
A lot of these things are going to be a tremendous surprise. By the way, that's always been the case. That is the household in which the student resides. Remember that it's the student who's staying with a parent one night more a year than the other parent. That's the determination. And people say, yeah, but this is a leap year. So there's 100, they each have 183 days. In that case, the tiebreaker is whichever this in the current system. Now it's whatever household the student's driver's license lists, that's considered the household.
Wow.
The new one will have, it's going to be financial support to the student, and then it's going to be adjusted gross income, and then they'll use the driver's license as the third one. But I doubt you're going to get the first two exactly matching up. It's possible, but many of them. All right. Even now in the current system, I always tell people if they come into my office and they're just starting exploring the divorce process, I would have them write immediately to the financial aid office of the college that their child is going to attend to say, look, we're in the process of getting a divorce, and our finances are clearly going to be different than they were 2 years ago when we filled out, the tax return that you're using now to determine our financial need. So contact them and ask them what they now want from you to provide as documentation of your changed circumstances. Remember that the Department of Education knows under this new system that you are, that they're using your prior year tax return. So for the students who are starting this coming fall of 2021, you fill out the FAFSA in October of 2020 and you're using your 2019 tax return. And they know that between 2019 and 2021, lots of changes could happen. You could lose a job. Someone could die in the household. There could be a birth, there are adoptions. Some people obviously get divorced, get married. Someone becomes disabled. Under COVID, you have significant medical expenses. They all know that these are things they now have to take into account. It's called professional judgment or professional discretion. I always advise parents saying this is not a right that you have. If you really, most financial aid offices are overwhelmed. They have a very high student caseload. And this is where honey is going to be far more attractive than trying to threaten anyone. But these are worthwhile. Now, we just missed, for most students have already had to make their decision for next fall as to where they're going. And the question always comes up, if we had this conversation before May 1st, the question comes up saying, you can sometimes also use professional discretion for negotiating a better financial aid package when you're comparing that school's package to another school's package. So, if I say, I would tell if I was a parent saying, look, my child really would love to go to college X, and call up college X financial office saying they really want to go there, and the college Y offered this, this package, which is now $5,000 more than yours, that really makes a difference to us. Can you manage to at least come close to matching that so our child will go to your school? Remember, financial aid officers are working in conjunction with admissions. They want admissions tells that they want your student to go there. And I will tell you another cue here, and that is when you're filling out the student, the FAFSA, there's a place where you can usually list what schools you want to have the student aid report sent to automatically. I think they give you a list up to 10. And I know that when I was a financial aid officer, I know exactly in what number I was, my school was listed. If I was a top 3 choice, I was going to be competitive. If my admissions office wanted that student in my school, I would be very competitive with a financial aid offer. If I was in the bottom half, I'm a safe school and I don't have to offer them anything more than, than the absolute minimums. So again, these are all parts of what makes up an offer. And remember that no school wants to have empty seats, because if that seat's empty for 4 years, that's lost income for the school for 4 years. So these are all part of the process. So professional judgment discretion can be used in negotiating for a financial aid package. You're a little late for this year, I suspect. Special circumstances now have been added to include the disability of a student or a dependent student's parent or an independent student's spouse. Those are all now new components that you can now ask for professional judgment or discretion. And certainly during qualifying emergencies. And sometimes that includes, wildfires, earthquakes, hurricanes, COVID-19. So these are all part of the process about, what documents you have to provide for unemployment benefits or things like that. By the way, for those who have been unemployed and are asking for judgment on this and get and get a better offer, you have to notify the financial aid office when you have obtained employment. If they find out that you got employed and you never told them about that, not only will you lose the financial aid that was awarded, but you may be forbidden from applying again. So they're putting some teeth into this thing as well. And the quote unquote emancipated student whose parents are not, who are refusing to fill out the FAFSA. They don't want the federal government to know what they're making or what their assets are. The student can now apply for a Stafford direct loan. They don't get the subsidized one, they get the unsubsidized one. But they're not going to get, they will not be able to be eligible for any other federal student aid. So no Pell Grants, no college work studies, but they could at least get a direct Stafford loan, because that was an error that they had omitted in the past, and finally they're going to correct that one. So a bunch of miscellaneous things, and I know we're running to my half hour here. Just know that the asset protection allowance, it's a pretty complicated process of what your income and assets are going to count towards applying for financial aid. They used to give a lot of protection for people. If you already had assets, it would protect, as much as $84,000. For most of our clients, that's not a very large amount. That has never been linked to inflation or anything else like that. So since 2009, its effective use is down to about $10,000. And my guess is the next 4 years, it will probably disappear altogether. The small family farms or businesses exclusion was eliminated. That's not a good thing. It used to be if you had a farm or that, they didn't have to include the values of those things. This is a potentially very negative thing, or people who own a small business. For those students who are in college, they're now eligible for Pell Grants. If you're under 33 and a parent died either serving the armed services after September 11th of 2001, or if your parent died in the line of duty, they were a public service officer, they now automatically get the maximum Pell Grants. You should know that we are all prohibited from charging a fee to complete the FAFSA. I've never charged anyone for doing that, but I know there are people who do. And the Department of Education is trying to get rid of those characters. So if you were in your practice as a financial person helping people do it and charging your hourly rate, you can't do that. Good news for those of us who were eligible for selective service all those many years ago, they are now no longer requiring male applicants to register for selective service, which is a great thing. And drug laws have certainly changed and morals have changed. If you were convicted for sale or possession of a controlled substance, you no longer forfeit your eligibility for financial aid. Ta-da!
Right.
Last thing before I think I got maybe a couple slides here. Income is also an income protection allowance. So I'm just going to skip that because that's not as critical a thing. It's happening in the background of the FAFSA. Did want to show you the poverty levels for those of you who have not been familiar with it. It is the 48 states and District of Columbia are one, and then Alaska and Hawaii are a little different. And you can see that if you're a family of 4, poverty level is $26,000. We're not talking about much. So when that earlier slide that talked that's 225% of the poverty level, it means you're still talking about $60,000, which is not bad. Because a lot of people who are, working class, even if, are probably going to be right in that character. So there are some good things here in terms of the eligibility things. So use this as an indicator for folks. And finally, the last thing here is, if you want to have some good ways to read at night to fall asleep, here's the URL for the 5,600 page document. And if you want to look at the FAFSA Simplification Act, there's the pages on which you can find it to put yourself to sleep. So that's my half an hour presentation. If there's any other questions, I know I went through this pretty quickly because I knew I had a half an hour to get it out there.
So I have a question for you, Sandy. Is there a philosophy behind these changes? And if so, what is it? I mean, is it to make it more difficult, more lenient, more what?
Both. So this is, again, I took my very first financial aid training, I think it was the spring of 1983. So, and I would say that in the intervening 38 years, there have been just some minor changes, but nothing major to FAFSA, to this whole process at all. It's been pretty much the same. They always only ask income and assets. They never ask expenses or debts, right? The reason they're not asking, they don't care about your expenses, and they're using the poverty level indicators, are because they don't want to be arbiters of standards of living or lifestyles. They're saying, you know, you spend what you want to spend on, but we're doing it based to make it fair for everybody. This is what we're using it for. You know, you can pick any system you want. Some people are always going to say it's not fair, but this is what the federal government felt was the best way. And they've kept it that way for 40 plus years, and it's not changing even under this. However, they are in this case allowing far more income sources to be excluded, which is again, a very positive change. I'm hoping and expecting that the biggest negative thing is probably that you cannot divide the expected family contribution among however many students there are going to be enrolled in college. I would expect that there'll be a lot of political pushback on that. And I will always tell my people, you know, contact your congressional representatives and say that is not a middle-class value here. Who's got that kind of discretionary cash to pay for it? That may be a way to potentially change it. Remember that most laws that Congress passes don't go through a lot of vetting, and consequently, when they write these laws, there's always going to be changes later in subsequent legislation. And you remember the first Tax Cut Job Act of the Trump administration, 2017. There were things that were handwritten on that thing, and it took them, you know, for some things a year or two to get those rules and regs published. In this case, while the Department of Education hasn't yet released rules and regs, I got to believe because it's a 167-page bill that Senator Alexander's office worked with the Department of Education. So there probably will be very few changes, and they'll mostly be political. I'm not sure if that answered directly your question, Carl, but.
So plus, net, do you think this is a plus or a negative for parents?
I think it's going to be dependent upon your circumstances. I think for most cases that I've seen, it's going to be a benefit. The ones that will be challenged is whether it will be which way it's going to go, or the people who've got more than one child in college at the same time. They will certainly take a hit. The question is whether they have income from those other sources that will no longer count. And certainly for those parents who were, well, two things would be negatives. One is it used to be that whoever the lower income parent was, we sort of de facto made them the primary parent. If they're even a 50-50 custodial agreement with the parents, you just say, well, so make sure that the lower income parent gets the child one night more a year than the other one. They can be the custodial parents, not a problem. That's no longer going to be an option to consider. It's now going to be strictly based upon financial support. So that's going to be interesting ways to sort of see if we can jury rig that, those abilities. Again, I don't know until I see the rules and regs as to how they're going to consider that, what they're considering. For example, what are they going to consider support? Is it just direct support to the student? They're going to consider child support as support. I don't know yet. You know, not just who's paying for college, but also are they going to look at other forms of support as well? Don't know that yet.
Okay. So when the law changes, you now use the income of the higher earning parent. I'm reading a question. Is that correct?
Not correct. Well, that's the tiebreaker. First is who's providing more support to the student. So whoever's paying more for, this is what's yet not finalized, but I'm assuming that it's going to be if the parent who's paying child support and the parent who might be providing other support on top of child support for all the things that child support doesn't cover. You know, think of out-of-pocket medical costs, think of, you know, extracurricular activities, all those things, plus whoever's going to pay most for college. Will that be the parent considered the most support? My guess is probably yes. Part of these things I'm trying to imagine if I was back in a financial aid office, how I would have to interpret this and what kind of documents I would require from the family to see this. So certainly child support is easy enough to document. Who's paying, you know, for college is easy enough to document, but I don't know what else they're going to count besides those two forms.
Okay. Now, the second part of the question is, what if the non-custodial parent refuses to complete the FAFSA?
So the FAFSA is only filled out by the custodial parent only. The student fills out the FAFSA, their portion, and the custodial parent fills out theirs. That's it. The non-custodial parent has nothing to do with the FAFSA whatsoever. They will, however, if this child goes to a private school, they would be required to fill out the college scholarships profile. If they, for example, refuse to fill that out, and if I was a financial aid officer, I'd say, great, your child's not getting any financial aid, period. I would put pressure back on the family. You know,
Okay.
the child is going to have to put pressure on the non-compliant parent to do what needs to be done.
How is alimony viewed? That's the question.
So this is always an interesting question since they changed the laws on this. So certainly for people who divorced before 2018, where it's going to be on your tax return, it still shows up as taxable income. That's still going to be counted. The challenge is going to be is when for people who got divorced after the law changed, since it's no longer taxable income, it doesn't show up on I don't believe it shows up on the tax return. Maybe someone out there can correct me on this one. And even if they did, I don't know how you would prove it. You know, so that's going to be an interesting question as to whether, and the new circumstances, it may not make a difference because they're not counting child support as income anymore either. So don't know.
Okay. Diana Longo has a question. Diana, unmute yourself.
Hey,
Diana?
Sandy.
Hi, Diana.
Hi, thank you. Thank you so much for coming in today. Your information is just really valuable. But I do run into cases where, you know, you have a woman, or let's just say like a non-gender, one spouse making a lesser income, needs skill development, and decides that the old system, well, you know, we have this one number for the whole family. I'll go back to college and possibly have higher financial aid. And that's something that, you know, someone who was a little savvy about college and financial aid, trying to, you know, negotiate alimony, et cetera, would say, well, if you go to college now, you probably get better financial aid. How is that going to be affected or possibly affected under the student aid index and the new types of calculations that are being done?
So in the new one going forward, this is one of those frown faces that was in the thing. This sucks, so to speak, for those people in that position, because I would sometimes counsel parents saying, look, if you are a half-time student at a community college under the current system, you know, when you want, you know, just going for it has to be for a degree-seeking program. It can't be for non-matriculated classes. You would count as at least a half-time student, and therefore, if you had one child, you could now, in theory, divide your expected family contribution by 2, right? That is no longer going to apply with the new system starting for the 2023-2024 academic year. So that strategy doesn't make any sense for financial aid purposes, but they still may need to do that for their own ability to increase their own income. And then the question would be, it may be irrelevant anyway, because if they're not the parent providing support, the most support to the child, but the other parent is, then they're not filling out the FAFSA anyway. So they're only filling out for themselves. And they may then qualify for a 0 student aid index based upon their own income and their assets.
Would it be fair to say that the average divorce mediator will not know all of this information, right?
Yeah, and I would say actually, I'm going to say the average certified divorce financial analyst may not know this either, because it's all brand new. But you know, my experience, and no offense to attorneys out there, is that you guys are great at legal and other things and writing up the agreements, but these are pretty nuanced finances, and I would strongly encourage getting people who are knowledgeable about this to help the family prepare best for getting optimal financial aid. I mean, I do a
So
lot of nationals consulting on these things because it's a 45 to 75-minute phone call, usually with families about how to optimize it under the current system. Haven't had to do that yet for people under the proposed system, but I suspect as soon as we get the rules and regs, we'll be able to do that too.
So a divorce mediator really needs someone like you as a resource for the clients.
For this narrow sector, I would think it would be important, but I don't even know that they will know as a divorce mediator that they'll even know that this is something that they need to worry about.
Okay, but they should be worrying about. I mean, are there a lot of people like you that know this material so that mediators, say in New Jersey, can have a resource, a list?
I'm doing my best to do a lot of these presentations all over the country to try and educate folks that they can help their clients. That's the name of the game here. So this is probably my 8th or 9th presentation so far. And I've still got a few more lined up.
So if a couple went to you and they wanted to have you explain it them all this to them, what would you charge a couple?
I charge my hourly rate, which is $2.40 an hour.
Okay, and usually how long does it take?
Yeah, well, under the existing system, because I haven't done one under the new system yet. Under the existing system, they take between 45 and 75 minutes, and I
Okay.
prorate my time.
Okay, so it's just what they use.
Yeah.
So what kind of if you know, what kind of language did mediators used to put in agreements, MOUs, and then got into the property settlement agreement with respect to these kinds of matters? And what changes now do they have to do?
Sure. So in the past, what I would create for my clients would be a spreadsheet as to who gets which child's exemption in which years. Typically people would alternate back and forth. I'm saying that's not necessarily the best for optimizing financial aid. Because of the 2-year lag, we can do it so that I always make sure that the parent with the economically disadvantaged parent would certainly have the children in their custody for the times you have to fill out the FAFSAs. Remember, FAFSAs are filled out a year before going to college, and it's based upon the tax return from 2 years before going to college.
Wow.
So you'd structure that first, and of course, anytime that the parent that there's more than one child going to school, you always give both children to the parent who could qualify for the greater financial aid, and then we could divide it by those students. And then what would happen is, because the FAFSA is filled out, the last FAFSA is filled out at the very beginning of your junior year of college, in your junior year of college, in October of your junior year. And so, but at that point, once you fill out the FAFSA, that's the last FAFSA you ever fill out. And I would then tell the parents that the non-custodial parent would get the child tax credit or the exemptions for that child's junior and senior years that fall over 2 different tax years. So they could get the parent who didn't get those credits before, he could get them at the back end. So, and I would create a spreadsheet that would show all these things, and that would get usually an exhibit as part of their property settlement agreement or their MOUs, whichever one.
Okay, so when would be the best time? This is a question. Let's see, when would be the best time frame for a parent to reach out for a consultation with someone like you?
It depends on on the age of the students.
Right.
Certainly if these are, if the college is already in students already in college should contact me as soon as they're thinking about a divorce. If they're young children, as long as they address it anytime during the divorce process before they have a final agreement, that would work too. So it really it's age dependent on the student.
Okay, so let's say you did one of those spreadsheets for a couple getting divorced 4 years ago, right? And it was just hunky-dory then, but their kids were young, and now they're about to go to college, but that doesn't apply anymore, right?
Yeah, I'm going to put up a sample of a spreadsheet if you can.
Sure, that'd be great.
I have to find it, which is So we can keep talking while I'm looking for it.
Okay, so the question is, if circumstances have changed since they consulted with you and the spreadsheet, what do they do now? They go back and
Yeah, so this is going to be the big question. This is a dated one. Let's see. I would say that I'm in the process now of contacting former clients, because the challenge is going to be anyone who's um, the challenge of trying to do two things at once. So I'm going to show you a couple of things on this thing. I'll come back to this. The challenge is going to be, in this case, I'm contacting all my old clients if they have a college, if they don't have children who are at least at the age of a high school sophomore. They're high school sophomores and younger. I'm not worried about that now, because because they have a little bit of time to apply. But I'm trying to get anyone who's got children who are going to be after when they're a junior in high school, and up until right now, students who are already into their first year of college. They are all the students are going to be impacted by this new change. So then for those students, that's the ones, those are the clients I'm trying to contact now, saying, you know, this is changing and we need to at some point talk about how to make this thing work for you. So I'm going to show a couple of things here just for fun and sillies. So this, by the way, is
well,
this
that's disturbing.
This is the flow chart. It's called, but if you can see this arrow down here, this is the simplified view of how the financial aid process actually works through the department. This is a Department of Education document. So I got a kick out of that. But now I'm going to try and see if I can find that spreadsheet. So hang it. So, and this is just a slide thing, but my thing's a little different here. So this is a dated one from an old version. This is the tax year. This is the FAFSA year. This is the year they go to college. And then, you know, if they have child A and child B, it says here the year they're going to start. You know, this is the sort of thing I would show to provide to the mediator or whoever's writing up the agreement, is saying which parent gets which child as the custodial parent in which years. And remember that it has, and we take into account that the impacts are both who gets to be head of household, which is, you know, roughly a $6,500 a year deduction, who qualifies for the child tax credit, which can be now, you know, either $3,000 or $500, depends upon the age of the student going off to college, and then who would also qualify later for the American Opportunity Tax Credit or the Lifetime Learning Tax Credit. So there's a lot of different financial components that are all baked into this thing to figure out what's going to make, how do you make it equitable for both parents, but still optimize it for their children for financial aid. I don't know yet how this is going to look for the new system until I get, I don't want to put something out here yet until I get what the rules and regs are from the DOE. So that's why I do these things like this.
Right. Well, the first chart was really disturbing. You know, how anyone figures it out and why it ever works is.
Well, it's been around for a long time, and whether, you know, how well it works is another story. But it works. And the challenge also now is that all my contacts with the DOE, everyone's working from home, just like many of us, and so it's a little harder in terms of trying to come up with rules and regs, and with everyone who needs to have input on that process to get them all together. I wouldn't want to have to be in DC at this time working during COVID.
All right. Now, here's a question. I don't know whether this is in your area. Is there a generalization as to which assets to liquidate first for college expenses?
Under the new, so under the current laws, I probably have I know I have a slide about that. It just took me too long to find it. So remember, any of the so the assets are pretty much going to stay the same. Protected assets are retirement accounts, your primary residence, those are all protected assets and they don't count. So that means that your investable assets, in your brokerage funds and your stocks and bonds, and if you have the 529 plan, for many people, that's probably as appropriate way if it's for an intact couple. I would probably start spending down the 529 plan, because remember, if I've got $100,000, not many people have $100,000 in their 529 plan, but if you had it there, the 5.64% assessment on that means that, already they're going to add $5,640 to your expected family contribution just based on that one asset, that 5.64%. So anything in those things that count, you might as well start using those up and spending them down. I oftentimes in divorce, I'd always would suggest to the non-custodial parent should be the one that owns the 529 plan, because then it doesn't count at all. And in the new system, it doesn't matter as long as it's anyone outside of your household. So when you have a lack of trust between soon-to-be ex-spouses, they may not want to give it to their ex-spouse, because after all, even though a 529 is designed for the benefit of the child, the owner of the plan can take out the money they want and just have to pay the taxes on it, and it's theirs. So sometimes you can make a sibling the custodian of your 529 plan too, to get around with that. But when there's no trust issues, and that the children are going to be taken care of by either parent, you would just switch ownership of the 529 plan to the other parent, and with an agreement saying if there's any funds left over, it gets split between the parents after taxes 50-50.
Okay. Another question. This one's it's not even a question, it's a statement. I understand that whoever claims the child on their tax return is the parent who fills the FAFSA for 2023.
There's no yes to that. So under the current system, whoever is the custodial parent would include that child in their tax return in the current system, and you would hope that would be the lower income parents. But for the 2023-2024 year, they might be actually bifurcated. So it doesn't matter who's going to declare the child in their tax return. It's whichever parent is providing the most support to that student, they have to fill out the FAFSA. So it could be that the other parent might have the child on their tax return, and the other parent may still be responsible for filling out the FAFSA.
Okay. So let's see. Anyone else? I don't see any hands raised. Any other questions? Going. Well, we're just about at the end. The timing is great. Anything else you can think of other than Jesus is really complicated?
Yeah, I apologize. I mean, it is complex stuff. That's just a 15-slide deck. My one for financial aid is 83 pages. So that's usually an hour and a half presentation. And I still get lots of questions with that. It's just, these are complex issues in and of themselves, and they're complicated in a divorce. So, they're challenging, but as my friends would say, who is a rocket scientist, this is not rocket science, and rocket science is a lot easier than financial aid. I think here the question is just get the best information you can, and there have been thousands, if not millions, of divorces that have gone on record without ever addressing the situation. So it's not like, we're trying to do the best we can for our clients.
Right.
We can do what we can do.
Okay. So you live on the West Coast, right?
Yeah. No early morning phone calls from you guys, right?
Right. Okay. But obviously you take clients from all over the United States. Okay. So when you send me your slide deck, which I'll distribute, just make sure you have all your contact information.
So I think on each slide, it has my name, phone number, and email address. So
okay. Is there an association or some other group of professionals who have the same knowledge level that you do, who also do this kind of work?
So there are a whole host of people who are financial aid consultants.
Right.
And they're usually tied themselves to high schools. And they're selling their services for a lot of bucks. They probably would understand clearly the financial aid structure and process, but they may not know how that works in a divorce.
Mhm.
But for many people, that may, and if there's I'm not trying to drive business to me, but if parents are already working with a financial aid consultant, they may just want to consider making sure that that person can guide them and probably can do a very good job, is my guess. Because this is what they do all the time as well, to help parents go through that, but they're mostly helping intact
Right.
couples. But there's certainly there's a large clientele base of people who are divorced. So the good ones also know how that works in a divorce too. So if there's someone that's more local, by all means, please go use them. And I'm going to try and train as many CDFAs and other folks as I can, because I will not be around for a long time. My days of retirement are not too long off here.
Okay. Well, Sandy, thank you very much. It was really informative. Clearly a lot to know for mediators. So thank you very much.
Well, thank you, Carl, and Diana too, for having me attend this session, and good luck to everybody.
Okay. And again, I will be sending out the slide deck as soon as I get it to everyone who attended. Now, just let's see, we have a webinar next Monday, which is on child support, and it's really for newer mediators. And then the following Monday, we have a mock divorce mediation where Andrew Jasani is playing the mediator, and it's going to be the divorcing couple are same sex. So that will be a good one as well. So see you the next 2 Mondays as well. Thanks, Sandy.
Take care, be safe.